Spirit possession, a phenomenon often relegated to the realms of folklore or religious belief, carries surprisingly complex and often overlooked legal and social implications, particularly in diverse cultural contexts. What happens when individuals or even legal systems grapple with actions or statements made under the influence of what is believed to be spirit possession? How do legal frameworks, especially in a country like India, attempt to categorize or respond to such phenomena? In this episode, my fellow editor Jairaj and I are privileged to speak with Dr. Saumya Saxena, an associate professor at Jindal Global Law School. Dr. Saxena's research offers a critical lens into these intersections, drawing on her extensive work in legal history, gender, and family law in South Asia. Dr. Saxena's impressive background includes her tenure as a British Academy postdoctoral fellow and affiliated lecturer at the Faculty of History, University of Cambridge, and her academic journey through the University of Cambridge and the University of Oxford. Dr. Saxena, we are truly honored to have you join us on the LSPR podcast.
Thank you,
To, be-
Aastha. Thank you, Jairaj.
to begin, for our audience who might be less familiar with the phenomenon, how would you describe the lived reality of spirit possession in India, particularly within the context you've studied?
So, spirit possession has seen a lot of attention from anthropologists. It's also seen some attention from medicine, psychiatry, psychoanalysis. In literature, you could say that a lot of people have studied folklore. They've studied about different kinds of, let's say, ghost stories that were common in villages, and urban legends, and so on and so forth. In the legal sense that I encounter, it's very rare that it happens, but sometimes cases of murder in particular, or where a death has occurred, these cases of spirit possession trickle into courts. And that is the bit that I'm interested in, because what it really means in the legal sense is that the idea of agency completely shifts, whereas cultural explanations accommodate for that. You could say, for instance, in cultural studies or in anthropology, there would be a certain conversation about the dispossessed body. So the body being used as a vessel where there is no agency of the person who is claiming to be possessed or is accused of being possessed. Whereas in law, that doesn't work. So that translation plays out in very, very different ways. Let's say in medicine, you have an understanding of spirit possession which could translate to multiple personality disorders, or different schizophrenia, so on and so forth. Similarly, in cultural studies, you have theories of dissociation, theories of communication, where the body is used to communicate about something else, about spirit of a late ancestor, or spirit of like a malevolent spirit, or a gentle saintly spirit, or a spirit of a god, spirit of a relative, spirit of a friend. So in anthropology, there's a lot of accommodation for this conversation. But in law, which is the kind of realm in which I'm investigating, very often you see translations of it. So when these kind of phenomenon translate to the legal register, very often it also carries the bias of the medical industry, which is then trying to translate a cultural phenomena into a medicalized disease kind of a phenomena. But the primary sort of interest for me is assessing how women fare when the supernatural enters the legal realm. So how do women really fare when we are looking at evidence which is about spirit possession, something that law is quite antithetical to, something that law is not quite willing to accommodate. And as we will discover in our conversation as it carries on, that very often it doesn't benefit women to have such ambiguity in law.
So, when stories of spirit possession, particularly those involving death, enter the judicial system as murder cases, what is the immediate challenge for the legal system, which is fundamentally rooted in a rational, evidence based paradigm? Can you walk us through how this reframing typically unfolds in judicial proceedings? And as this plays out, how does it powerfully invoke the tradition versus modernity trope?
Okay, so I'll answer this question in two parts. First, about the reframing, which is my primary interest, and then I will also talk about how the tradition versus modernity trope is deployed in the legal sense. So, reframing magic in legal terms is, let's say, primarily what I'm investigating, which is why the paper is also titled "Ghost in the Courtroom," which was meant to be play on the words "elephant in the room," because the courts never actually openly acknowledge that there is any merit in a story like this, because they are supposed to be drawing the boundaries between the rational and the irrational, between the educated and the uneducated, the superstitious and the educated. So a lot of this boundary setting takes place within the space of the court, because they have to use witness testimonies which are, let's say, fundamentally unreliable because they are invoking ghosts and spirits, and they have to translate them and use them to establish a case where a crime has taken place, where a death has occurred, or where a murder or abetment to suicide has taken place. So the way in which the way in which the boundary setting takes place is that the court is very emphatic about separating the rational for the irrational. What it really means is that we are working with very different conceptions of justice. So, for instance, very often, what is justice in the local narrative may be completely reversed in the legal narrative. So, I'll give you an example. So, for instance, there has been a witch who's been hunted in the local narrative. The local panchayat or the local people might actually believe that this was a curse that has been lifted from the village, whereas the work of the law is going to be to completely reverse this premise and say that no, this woman was murdered, and therefore the actual culprit was not the woman but the people who killed her, right? So very different places where you can say justice is located. If we were to invoke Foucault, also the way the local and the legal look at the same problem, there's a very different way in which they also locate power. So, in the local narrative, one might say that the power might, in some sense, lie with the victim who suddenly kind of rises to power in the moment of possession. But in the legal sense, if such a case were to reach the court would say, "Oh, this person was insane, or this person didn't know better, and they were superstitious, or they were of unsound mind." So, I can actually walk you through some of the defenses that are actually used. So, one of the ways in which this plays out, this ambiguity plays out between the cultural and the legal context, what it means for the law is simply leniency in punishment, leniency in sentencing, leniency in conviction, and that is the broad way in which the free reframing affects individuals. But how does it actually take place? The first thing that a story around superstition will injure is the idea of mens rea. It's extremely difficult to establish criminal responsibility, because very often the defenses that people will use would be insanity, incapacity, madness, mental breakdown, illiteracy, superstition, unconscious crimes, and I quote, this could be committed by a person of an unsound mind, triggered in self-defense, lacking in intention, mistake of fact, acting in good faith. All of these sentences, all of this terminology is deployed mainly to basically, create leniency in sentencing. Whether it's intended to do that or not, what the ambiguity ends up creating is leniency in sentencing, because it's really difficult to establish agency. Culturally, of course, like I said earlier, there is a way to accommodate this. There is a way to accommodate narratives around revenge, narratives around shame, narratives around this occurred because, a calamity fell on the village a month earlier and somebody was held responsible for it, and everybody locally is complicit in it. So, what does that mean for law? That conviction is difficult because you don't know how it began. You don't know if there was one person responsible, or if there was an entire village responsible, or if there was a particular caste or a group or a family that was responsible in creating this myth of this person being possessed. So all of this ambiguity translates as, in one sense, difficulty in establishing mens rea. To give you a quick example of how it benefits sometimes the culprits is, okay, so this is the case that didn't reach the courts at all. You might have, and I'm only using this because it's such a popular example, the Burari killings that happened in Delhi, right, where 11 members of the same family were convinced by one of the brothers, the younger brother of the family, and he was convinced that the spirit of his late father overtakes him, and whatever he says thereafter is basically the will of the father, and he convinces his entire family to indulge in this sort of a mass suicide, right? In this case, there were no survivors, so it became a case which is relevant to the law to the extent of it involving a police investigation, but it's not relevant in terms of punishment and sentencing and conviction, right? But a similar case happened also in 2018. This is the case of Sanjay Nagarao Pote. And this was interesting because in this case, a man similarly claims that he was possessed by the spirit of the Lord Hanuman. And he says that in his moment of possession, he accused one of his relatives of being possessed by a spirit. And he said that I will now go on to perform an exorcism on you. And in the process of that exorcism, the person actually died. And the entire family kind of witnessed the act. They were all complicit to the extent that they didn't quite try to prevent it, because in their minds, they were executing the will of the God, right? So the will was not of the individual. And the court, the Bombay High Court in this case, actually acquits the person, because they say that he really did not know that he was actually committing a crime. He was doing this because he was executing someone else's will. So they will of course not accept that this was actual execution of the will of Lord Hanuman. But what it does mean is that it's difficult to establish an offense when the person is a person of an unsound mind. So again, what it really translated to was leniency in sentencing. So that's how kind of the reframing takes place, and that's how the reframing affects the individual. Now, the second part of your question, and I'll try and be quick. This is about the tropes of tradition versus modernity. So we know that this was very common since colonial India. There was a conversation around civilizational superiority, where there was the history of British India written by James Mill. A lot of conversation around how Indian tradition was meant to be unfair to women, how it was Indian religion was meant to be paganistic, and all of that. And in order to counter that, there was this huge religious reform movements in 1800s and so on. Now, this framing has carried on in post-colonial India as well, and the way in which the divide from, let's say, native superstition against legal, rational, civilizational superiority translates to educated versus uneducated, rural versus urban, so on and so forth. Having said that, in post-colonial India, because my archive is not strictly looking at judgments, of course, are a very distilled version of the story. I also look at police records. I also look at legislative assembly debates. Very often, what you would find is that despite there being a conversation around, oh, tradition versus modernity, and tradition needs to be curbed through modernity, there are actors who are involved in the act of executing the law or implementing the law who may be believing citizens. So you would find that, let's say, the local police officer or the investigating officer who's supposed to spread awareness about how witchcraft or witch hunting is a bad idea, or let's say sati is a cruel idea and it's not legal, they would be individuals who are also believing individuals. So in the police records that I found, there was like some hesitation on part of some police officers to investigate at night, because the local folklore also affects them. So to think the tradition versus modernity, I could even say that it's a upper judiciary versus the administration locally on the ground kind of a debate. Because it could also be that the judge adjudicating the matter is also a believing citizen, but the law itself is meant to lead to read rationally. So that is what creates the ambiguity. That is what allows us to introduce leniency in sentencing, which I go on to argue is detrimental to women in most cases. But this ambiguity is generated because believing citizens are dealing with rational law. So that is the way in which one could argue that tradition versus modernity takes a slightly different role post-independence, because we are also post-independence not necessarily trying to shun religion, right? Post-independence, it's also about salvaging religion, because Hindu Code Bill is sort of being debated in 1950s, immediately post-independence. So it's about separating faith from fallacy. So even religion is becoming, in one sense, getting rid of its mortifying principles which are associated with superstition. So post-independence dealings with superstition or dealings with religion are not about rejection of tradition. It's about dealing with tradition. It's about dealing with religion, in one sense, sanitizing religion to separate it from tradition. But it does take a slightly different tone than what it was in colonial India.
Thank you, Professor. Your research interests include gender, family law, secularism, and politics. The abstract of your paper also mentions that women often have a very specific experience of possession, reflecting unequal power relations. How does the ghost in the courtroom phenomenon connect to and illuminate these broader areas of your expertise? Beyond gender, how do factors like caste, class, or other vulnerabilities intersect with experiences of spirit possession, both in its occurrence and in its interpretation?
Okay, so family law was actually quite comfortable as a discipline when I moved from family law to starting to study spirit possession, because I was already working with negotiations of religion with the state. So secularism and family law kind of is a very, good example of how these negotiations take place. And at some point, religion and the kind of the sanitized, creating sanitized versions of religion through codification of law worked quite well with what religion tries to separate was very often what superstition was. So in that sense it really did tie in with my research. Another aspect that tied it with family law was very often the people most vulnerable to possession, and this is evidence I picked from ethnographies and anthropological writing on the subject, happened to be new daughters in law who were kind of entering these new families. So very often the family dynamic or rights of women within families was still relevant to this project. Um, the other question that you asked, so basically, when it came to gender, um, the general misogyny that characterized women's interactions with the state, in one sense, I found compounded when there was an element of superstition involved, because alongside the gender state patriarchy, which let's say women are encountering in cases of domestic violence, in cases of divorce, when there is greater ambiguity, that greater ambiguity also goes on to benefit patriarchy. So in the gender sense, it was kind of a very easy flow because I was already reading like a bunch of stuff on gender, and the theories of possession and the conversations around gender made me think that so far as the law is concerned, I know in anthropology and in culture, there is an argument about gender not being necessarily a very useful category of historical analysis. But when it came to law, it still was, because law works with categories. So to that extent, gender remained quite relevant. How does caste and other vulnerabilities, how do they play into this conversation? So basically, caste is everywhere. Unless we are consciously trying to overlook it, caste is literally everywhere in every conversation. In spirit possession, again, so I'll borrow some evidence from anthropology to talk about what the lit review really looked like on a subject like this. So there are lots of writings about how possession worked among different castes, so castes and classes. So Karin Kapadia's work talked about alaku, which is a kind of possession that takes place among Dalits in Tamil Nadu. She compares it against the sort of temple dancing kind of trance possession which occurs to Brahmin men. So there's a lot of writing on that. There is also a conversation around, so Clarinda Still's work also talks about Dalit families in particular and how they experience possession. I remember, I think it was Fuller or Freed and Freed, one of them make the argument about how in a local village, there was a person who got possessed and he was a person of a particular caste, but through his possession, because he was in a position to predict futures, he placed himself in a position where he had the powers to bless and curse. He actually managed to elevate his caste status. So lots of negotiations here as well. Even with gender, lots of negotiations. I think it was C.J. Fuller who calls spirit possession culturally tolerated opportunity to complain about female subordination, because he talks about incidents where women in a moment of possession would ask for non-vegetarian food or eggs, things that they were not otherwise given, or things that they, let's say, caste forbid them from eating, but in a moment of possession you could demand, so you could ask. And this kind of takes us towards a very functionalist definition of possession, that through possession you communicate or through possession you negotiate. But caste plays into it in a very significant way. And a lot of anthropological studies kind of talk about this upfront and talk about the different kinds of possessions that affects different castes and classes. Legally, how does it play out? In law, it plays out, and this will become more clear as we discuss some of the cases. In law, it plays out again very typically the way it does in any other realm of law, which is that there are certain ideal criminals that the law unfortunately recognizes, and there are certain people who are given a greater benefit of doubt in the law. So, if, for instance, a husband is claiming, as we'll see in the examples that I go on, if a husband is claiming that his wife was possessed, and this happens to be an upper caste family, the court is likely to look at expert testimony for insanity and acquit the husband. Whereas, let's say, if the receiving end of the law is somebody who's died who happens to be a tribal or a lower caste individual, the court is, in my experience in the case law that I looked at, and we'll discuss it shortly, the court is very likely to say that, oh, this was a community that was given to to believing that supernatural spirits exist. And so basically, a tribal person's death due to an accusation of possession or by an individual who said that they were possessed is likely to draw less sympathy of the courts, less sympathy of the police compared to a person of an upper caste origin or somebody who happens to be male. So the way in which this plays out in any other realm of law is very similar to how it plays out in cases of spirit possession, which is that greater sympathy is reserved for who the state recognizes as a default subject citizen. A lot of writing on gender and a lot of writing on caste and the law will tell us about whether you performed as a good citizen before a court, whether you were an honorable wife, whether you were a non-adulterous food preparing wife, will determine whether a domestic violence case goes for or against you, right? So courts are, I mean, Srimati Basu's work talks about this in context of domestic violence in an incredible way. So she shows a lot of evidence about how if women could prove before a court that they were good wives, they're less likely to be, they're more likely to get the sympathy of the law. So similarly, in cases of possession, I found that depending on who you were as an individual and how you presented, the courts are likely to sympathize with you if you happen to be from majority religion or somebody who was upper caste, male, where the court kind of reserves its sympathy for you. So that's the extent to which I think caste kind of overlaps in this conversation, and that's how you recognize vulnerabilities. It's quite common across the board in all realms of law.
How did the colonial legal system grapple with evidence of the supernatural? And are there continuations or ruptures in how the post colonial Indian courts approach these issues compared to their colonial predecessors? How does this compare with broader post colonial treatment of colonial norms and procedures?
Okay, so with when I compare it with colonialism, I don't necessarily see 1947 as a big moment of rupture or a massive moment of continuity, but the presence of the constitution does change quite a few things. So the bit that I mentioned earlier about the Hindu Code Bill actually does play significantly into the post-colonial psyche and looking at religion. So in one sense, religion was not something to be discarded; it was something to be reformed. It was something from which you could pick common sense good principles and codify them and discard what was supernatural, right? In colonial India, there are some very distinct decisions. I mean, two of them being, I think it was Vardyam Singh versus Emperor and Buddha Kui versus Emperor. These were the two decisions which are about how the law would treat you if the person you killed happened to be a ghost, right? So the colonial law was approaching it as also this is native superstition. How do we deal with them? Do we deal with them sympathetically? We'll deal with them sympathetically because they don't know better. So a lot of this colonial superiority also came from rejection of tradition, and we know that the conversation between modernity and tradition very often takes place in the body of the woman. So be it a conversation around sati, when the British were kind of trying to get rid of sati and say that this is no longer legal. The Indian response to sati was, on the one hand, yes, this is not true Hinduism, so we should definitely. This is Raja Ram Mohan Roy's letters to the government, where he said that this is not true Hinduism and therefore sati should not exist. And there is the other kind of a revivalist, response to this, which says that no, sati is something that is central to Hinduism and therefore you shouldn't interfere in tradition, right? So these two responses in post-colonial India would, of course, be slightly different because in post-colonial India, it's not as straightforwardly a conversation between British men and Indian men on the fate of Indian women. Indian women do kind of within 1950s, because of the conversation around Hindu Code Bill and the presence of the AIWC and other such bodies, they are kind of having a conversation with the government about law reform. But at the same time, some of the tropes still carry. So, for instance, post independence, the Indian courts as well as Indian Parliament, Indians in general, are still dealing with cases of deaths of women. This could be over sati, which didn't disappear after independence. It could be over accusations of witchcraft, but most commonly it was because of dowry. Right? So women were dying for various reasons before and after independence. And the way in which the state was responding to it may be mildly different. Right? So, of course, for dowry, there were very specific legislation and conversations that happened. Sati, again, there were big moments and small ones, but sati didn't disappear immediately upon independence. For spirit possession, we don't see legislation until much later. So because spirit possession was something that nobody wanted to acknowledge was still happening, right? It was supposed to be this practice that doesn't happen to urban areas, it doesn't happen to educated people. So it was something that the post-colonial state is not engaging in immediately upon independence. But nevertheless, I mean, there is also, one could say, a conversation about whether the category of supernatural itself is Western. So I don't get into this in the current paper, like in the paper that I'm currently writing. But of course, it's still, here I'm using terms like spirit possession and, demons and black magic relatedly, but not interchangeably. But post-colonial categorizations of witch hunting don't come in until 2000s. So it's only in 2000s that, Odisha, Jharkhand, these states were kind of having a conversation around it. Before then, sati is still a bit mainstream, but nobody wants to talk about the fact that women are also being accused of being witches and being killed. So, which is why I don't see the moment of independence as a massive rupture. So that rupture doesn't necessarily take place, which is why it is so understudied in the legal sense, right? This conversation around spirit possession has been the preserve of anthropology, psychiatry, medicine, even, but not law. So it's only now that we're seeing more conversations around it.
Right. Now we'll move on to a set of questions based on specific cases. The first case for our discussion today is State of Odisha versus Ram Bahadur Thapa. So the first question for this case is, Professor, could you briefly set the scene for this case? What were specifically the central facts that brought this case before the court, particularly those involving allegations or beliefs related to spirit possession?
Right. So Ram Bahadur Thapa is such an interesting case. I'll tell it like a story, and then we can see where the law is involved in it. Because in the case itself, it is narrated like a story. When I was reading it, it didn't feel like it was a legal document at all till the very end, where they actually get into why this person was not convicted and so on and so forth. So basically, in 1958, there was a man called Ram Bahadur Thapa. Now he was, as the case mentioned, he was a servant or a helper of this other person who was working in Calcutta, and this person was contemplating buying arrow scrap. And in order to sort of make the bid and to assess the materials, he moved to this remote village called Ras Govindpur in the Balasore district of Odisha. He was visiting this site, inspecting it to figure out was an abandoned aerodrome. So he was wondering what arrow scrap he might use for his business and so on and so forth. And some of it might have had great resale commercial value. So he was assessing this area. Now he was staying near this village, but this aerodrome had acquired this notoriety about being haunted. And again, the judgment says that the area was inhabited by Santals and Manjis, tribal communities. Both communities had a very firm belief in the supernatural and in ghosts, and they believed that the aerodrome was haunted and completely infested by ghosts, in quotes. So Ram Bahadur Thapa is, of course, he's accompanying his employer, and they're assessing this scrap, and they're very excited by the rumors around this aerodrome. So in the middle of the night, they're just having tea at a tea stall. They're also accompanied by their landlord. So they were living in a place near the village, and the landlord, who's also quite his name is Patro, so he's also quite excited by these rumors. And at one point, it was their idea to start exploring or go near the forest because they were excited by the idea of encountering ghosts. Now, this is when things become a little interesting, because on their way back, they took a footpath along the aerodrome where they saw flickering lights in the distance. to add to the setting. And this I quote from the judgment. It sounds like a story, but it really is the judgment. To add to the setting, uh, strong winds blew through the area and they made the ordinary flickering light look like will o' the wisps. Now, will o' the wisps, as you know, is like a flame like phosphorescence, which is generally emitted in marshy areas caused because of decaying plants. But in literature and in folklore, this has a history of being associated with danger or even death because it's said to lure unsuspecting travelers into the marshes. Now, the trio, this is the employer, Ram Bahadur Thapa, and Patro, who's the landlord. They're kind of walking alongside this path where they see what they believe are apparitions around this light, and they put it down to being ghosts dancing around the fire. Instead of running away from it, for some reason they run towards it because they're really intrigued by the idea that they might be encountering ghosts. Thapa was the first one to reach, and Ram Bahadur Thapa, this is relevant later, is a Nepali man, as one might be able to tell from his name. So he reached out with his kurki. Now, kurki is also a small, you could say, pocket knife, which is quite closely associated with Nepali identity and that stereotype. And he began to indiscriminately attack who he thought were ghosts. The only established piece of evidence was that all individuals involved were obsessed with the idea of ghosts. The figures spotted moving around the flickering light were suspected to be ghosts by Ram Bahadur Thapa. And once he began to attack them, it was only in his zeal to kill the ghosts that he also managed to attack the landlord, Patro. And then when Patro screamed, this is when Ram Bahadur Thapa is kind of brought back to his senses. So this is to say that he was not in his senses before. He was brought back to his senses when Patro screamed because he was injured. And this is when he realizes that actually the people he was indiscriminately hurting were Manchi women who were simply performing a morning ritual, and they were the inhabitants of this village. Thus, the court says, relying on Section 79 of the Indian Penal Code 1860, which states that an act is not considered an offense if it was done by someone who was justified by law or who believed they were justified by law due to a mistake of fact. So for this attack, even though Thapa was charged with murder, so 302 under IPC, he was also charged with 324 causing grievous hurt or hurt, and Sessions Court judge acquitted him of all charges on the grounds that these acts were committed under a bona fide mistake of fact, thinking that he was attacking ghosts and not humans. And the Varyam Singh versus Emperor is also a precedent, which is about what should happen when the person you're attacking is you think them to be ghosts. Now, the court here takes actually a very sympathetic view of Ram Bahadur Thapa's situation, which could happen because of various reasons. But their own reasons were that he was a newcomer. He was not familiar with the region at all. So he was a newcomer here. He did not know that there was a rumor about this place being haunted. He was not accustomed to it. He was probably overwhelmed by it. The court also reiterated that the aerodrome was in general meant to be haunted, but particularly haunted on Tuesdays and Saturdays, which was one of the days on which this incident occurred. All these factors were used as mitigating factors in favor of Thapa to ultimately decide that he had not killed knowingly. He had killed who he had thought who he thought was a ghost. Another thing that the court observes is that the status and intellectual attainments of the respondent, the place and time of circumstance, it would not be proper to expect that a Nepali should have paused and examined. So maybe if an Indian was expected to do it, but the fact that he was Nepali was also factored in this judgment, and it was not basically proper for us to expect that a Nepali should have paused and examined carefully whether the persons moving around were human figures or not. The court also goes on to say that he was not corrected by people who were better educated than him, like Patro and like his employer. So they didn't make any effort to educate him. So he was not somebody necessarily of unsound mind. So they don't use 84. They just use 79 to basically say that he was somebody who thought that these people were ghosts. And in this case, one woman had died, two were severely injured. But it is for us to think about whether if these women were upper caste, urban women, would the court have responded similarly? Are the lives of women who are tribal, who are anyway on the peripheries of the society and of this village, were their lives basically of less significance? Would similar sympathy basically have also accrued to somebody else in Thapa's position? But the reason why this case was interesting because of the way in which these translations have taken place. So he was Nepali, he was not somebody as educated, educated people around him didn't tell him any better. So this was kind of the story that unfolded, and he was ultimately acquitted of all charges.
So quite interesting. So how did the defense in this case attempt to leverage the concept of spirit possession? Specifically, how was the argument framed around the legal defenses of insanity, Section 84 IPC, which is now Section 22 of the BNS, or mistake of fact, which is Section 76 or 79, now 14 or 17?
Okay, so they did not necessarily, they couldn't prove that he was insane in the sense that he was somebody who was maybe not in his senses at the moment. But there is also, I think, an understanding of uh, lowered cognitive capacity. So he could not understand in that. So he was not insane or a person of unsound mind generally, because that would, I think, entail greater proofs, psychiatric opinions, and things like that. So none of that was necessarily required because this person did not necessarily try to evade conviction or run away or anything. So basically, he was just basically incapacity to understand is a little bit different from unsoundness of mind. And so the case was really built around mistake of fact. And that is also what makes it really interesting for me, because it seems like the threshold is then quite simple. One could simply claim that they were superstitious, they didn't know better, and then that becomes one of the ways in which you manage to evade conviction. So he was not he was mistaken, he was not insane, is what they base the defense on.
My next question is from a legal history perspective, what precedent or significant interpretation did the judgment offer regarding the interface of traditional beliefs about the supernatural with established criminal law defenses like insanity and mistake of fact in early post colonial India?
Right. So there has always been, let's say in India, a tremendous interface between traditional beliefs and the law, right? So even post-independence, our secularism was not necessarily about a separation of state and religion as one may understand it in the sense of like Western jurisdictions and how they do it. But in India, it was always about management of religion, right? So it was not just a question of, let's say, personal law where law is being codified, but you take temple entry movements, right? So everything was about a negotiation with religion or negotiation with tradition. One can say that temple entry, how much of it is about caste, how much of it is about tradition, how much of it is really about religion, right? So in India, secularism was always about management of religion. And to that extent, I mean, I say this because I don't see Ram Bahadur Thapa from a legal history perspective and not a lawyer's perspective, because I'm not one. So, from a legal history perspective, um, particular judgments or significant legislation is what I'm trying to decenter from, because what I'm trying to show is kind of a long durée of of Indian history where we study how the state responds to questions of tradition, questions of gender, questions of spirit possession, and not, I mean, Ram Bahadur Thapa in one sense is not a significant decision because in a lot of ways it fits in with what was happening in colonial India and what continues to happen with post-independence and in contemporary cases. So I suppose my persuasion here is to understand how much relief can belief afford you. Okay, so that is one of the ways in which I investigated. Now, what laws you mentioned about unsoundness of mind and mistake of fact and other such related sorry, I'm just going to plug in my device in a second. So basically, crime without intent. Okay, so crime without intent, crime committed in an unsound state of mind, or crime due to mistake of fact has one more ally, and this ally is called grave and sudden provocation, which I'm sure you all as lawyers are quite familiar with. But the point that I'm making is to actually link all of these defenses to have a conversation around what are your bargains? What are your bargains when you're making a case for leniency in punishment and there is a ghost involved? So grave and sudden provocation, I want to talk a little bit about this in context of insanity and mistake of fact, because in one sense, this is another way in which you reduce murder sentences to, culpable homicide, right? It's very commonly used to say that, oh, it was grave and sudden provocation, and therefore it's not murder, it is culpable homicide. And it was most common in adultery cases. So here I want to take an example from Alistair McClure's cases on criminal trials from colonial India. So he works on 18th century, 18th, 19th century period, and he's looking at this defense, which is also called the mercy for an unreasonable man. And this will kind of tie in with what you just asked about mistake of fact. So McClure talks about the mercy for an unreasonable man, who is a man who's claims a cultural defense. Culpable homicide is not amounting to murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of a person who gave him that provocation, or causes the death of any other person by mistake or accident. Okay. He talks about, so this is McClure's research, he talks about a man called Mohan who murdered his wife on suspicion of adultery. And to this, the court responds, natives of this country, in cases of this description, appear to be generally unable to exercise control over themselves that Europeans usually succeed in doing. So now you see the parallel with Thapa, right? Nepali, we can't expect him to have known better. Maybe perhaps Indians would have known better. So there's like this not so subtle racism built into like adjudicating such cases. And second, the court continues, the prisoner, moreover, is an ignorant man. So again, parallels with Thapa, where Thapa was considered somebody who was mistaken because he was an ignorant man. He didn't know better, right? So in this case, husbands were not the only beneficiaries. This is all, again, McClure arguing they're not the only beneficiaries in this process. But what began as loosening of adultery defense in the colonial context also grew into a broader tolerance of all male families members' right to violently police female sexuality within the household. Another case that McClure talks about is from 1896. This is the case of Chunni, who once comes home late at night to find his sister having an illicit connection with another man. He had heard rumors about this man having an affair with his sister, but he had never actually actively witnessed it. Having seen them together, in the act of adultery, or not adultery in this case, in the act of, intimacy, he picked up a nearby gandasa or a blade and he killed them both. The Sessions case, in the case of Chunni, found Chunni guilty of murder. However, on appeal to the High Court, the court considers this case and wonders whether it might fall within the exception. Here, the judges explain that there was a clear distinction in the degree of provocation between a case like this and and the provocation that is felt by a husband who finds his wife in the act of adultery. However, they noted, English law was very strict in the matter, but they conceded that the dishonoring nature of his sister's actions to the family constituted a very grave provocation. So they're trying to kind of accept a cultural defense and be like, we know this is hard for you lot. We know that this is a huge matter of shame for you all. So the English law is very strict on the matter, but they found Chunni guilty of culpable homicide, not amounting to murder, and sentenced him to rigorous imprisonment instead of death, which was the case for murder, punishment for murder at the time. So the general trend here that I want you to kind of, that I want to emphasize in this is that emotions of men very often through these, legal provisions like mistake of fact, grave and sudden provocations are more easily accommodated than transgressions of women. So women transgressing and that provoking a man to action or anger is a situation where the court will be like, oh, we understand this must have been a grave matter of shame or anger or fear for the man. But the woman who transgressed, who was with another man or who was committing adultery, which, could be a civil offense and so on and so forth, that is given relatively less sympathy. And which is why it is not about sort of isolating Ram Bahadur Thapa as a case, but what it necessarily stands for is the way in which the court, through various cases, is accommodating the emotions of men over transgressions of women.
So moving on to the next case we will be discussing, which is Madan Singh versus State of Rajasthan. Professor, could you briefly outline the factual background of the case for our listeners, particularly highlighting how the element of spirit possession came into play and by whom it was alleged?
Okay, so in Madan Singh, it doesn't compare quite directly with this. The reason, I'll tell you why I use the cases together, but in terms of the invocation of the supernatural, it doesn't happen in the case of Madan Singh itself. The reason why they compare is because in cases of Sati, just like in the cases of witch possession, spirit possession and witch branding, very often it's very difficult to make conviction. So even in Madan Singh, initially after the case of Roop Kanwar, and her after she committed or was made to commit sati, there were thousands of people who witnessed, 45 people initially accused, 12 people all acquitted, then 12 people later accused again, also all acquitted, and ultimately till date there is no one gets convicted. Now this was for very different legal reasons. This was because eventually the defense that they had was that the pyre was lit by the younger brother of the deceased, and he was a minor at the time, so he could not be convicted. Another reason why there wasn't conviction is because Roop cover was basically, I mean, it was basically an argument about whether it was murder or abetment to suicide, and while abetment to suicide could be proven, murder could not, and because they kept alleging murder for various reasons, the case did not nobody was necessarily convicted in this case. But the reason why Sati compares to cases of witch branding, because in one sense, again, the broad argument here is that no one killed the goddesses, because in the moment of Sati, the woman is kind of elevated to a position of being a goddess. So in local terms, it's very often called Sat Chad Jana, or being possessed by Sat or truth. So this woman is suddenly elevated. So no one killed the goddesses because it's difficult to make conviction, and too many killed the witches. Again, it's difficult to make conviction. And that is how Sati and witch branding kind of somewhat compare. Because in both such cases, there is a conversation around how do you make conviction when when the responsibility for the crime is so decentralized, right? So in one sense, they both entail rituals, and it's very theatrical. Witch branding is theatrical. It's always been since 17th century European witch hunts, where women were burnt at stake, to sati, where women are burnt at the funeral pyre. The events surrounding both these events, the kind of events surrounding both these ends, tend to be that there was some magic involved. So in the case of Sati, and Ved and Sangri have a paper on this, they talk about how miracles are invoked. So henna or mehendi appeared on the hands of the woman magically. Nobody applied it, it just came out of nowhere, right? So these are the narratives that lead to Sati. So other narratives, like when the police is trying to investigate, and this is the reason why conviction doesn't take place, because when you ask witnesses about what they saw, they say nobody really put any fire or oil on the pyre. The woman was just sitting there and there was this spontaneous combustion, right? Because that is what magic does. That is what faith does. It blurs out evidence. It blurs out, it makes witness testimonies irrelevant, because what you want to believe in is the magic, right? So other testimonies for Sati, not necessarily in Rup Kamar's case, but other cases were about how the woman flew to the funeral pyre of her husband, and there was nobody who assisted her, even though it is 12 feet above the ground, right? So in Roop Kamar's case, she was drugged, most likely, and that is what the investigations found, that she was drugged before she was taken. But yet no one gets convicted. So that kind of makes Madan Singh comparable with the rest of the cases that I'm talking about, but in the sense that it's dealing with Sati, not necessarily in terms of what its legal findings are. It doesn't make conviction, and that makes it comparable to Sati cases.
Given the broader theme of Ghost in the Courtroom, what does the Madan Singh case reveal about the judiciary's approach to tradition versus modernity when confronted with supernatural belief in a legal setting in the late 1980s? Particularly from a legal history perspective, how does Madan Singh fit into the evolving jurisprudence on mental state and culpability in Indian law, especially when traditional beliefs about possession are introduced as a factor?
Okay, so I'll maybe to answer this question, lay a bit of a background in which about the way in which the case actually took place and what was going on locally. So in Deorala, Rajasthan, there was this 17 or 19-year-old woman who was made to accompany her husband to his funeral pyre and burnt along with him, and her husband Mal Singh. And the case was initially reported in an obscure daily newspaper. But later on, it was only when the English daily Indian Express picks up this case is when it becomes of somewhat, national relevance and national importance. Now, three local women's organizations, and Kavita Srivastav writes about this in around this in 1987. So she talks about how these local women's organizations kind of start talking about how this needs to be stopped. And one of the local women kind of they open a school, a local government school. They open its premises for having conversations around what to do to curb it. And because sati had been taking place, this just became a bigger case because of these events that I'm narrating that made it into a bigger case. But sati, which was what I was previously working on, it in post-colonial India did occur, and it occurred as frequently as one case of sati per year in 1950s and 60s, and slowly tapers towards the 70s. But in 87, when it takes place, the National Federation of Women takes it up. The local women's bodies in Rajasthan are very active, and they seek a meeting with the local CM, and they say that we need to have a conversation around why these cases are still occurring. Now, significantly, this meeting only lasts for 2 minutes with the chief minister, and this meeting is then followed by chief minister's meeting with another body of Rajput youths who are speaking in defense of sati. So on the one hand, there is National Federation of Women, which is galvanizing, women in different parts of India, and they are being sort of treated as elitist or Western by the local bodies such as Sati Dharm Raksha Samiti, and Radha Kumar also works on this. So she kind of demonstrates with images in a very interesting way about how these two organizations are clashing. And normally you would think this is so straightforward. Of course, everybody would be against it, but that wasn't the case. Now, to what extent you also talk about, whether tradition modernity, where does it fit? Now, when we apply tradition modernity trope, you would think that in colonial India there was a religious defense for sati, right? That doesn't happen in the Roop Kanwar case. That doesn't happen in 1987, because the Arya Samajis, a lot of religious leaders at this point are trying to distance Hinduism from sati. So you could say it's a conversation around salvaging religion rather than salvaging the woman, but it's about salvaging religion and saying that, look, sati was not a part of our. So, very Ram Mohan Roy kind of argument, but it's been made in a very sort of distinctly modern context. The way in which the reason why this case becomes what it does is because the National Federation for Women, along with a bunch of other feminist organizations working from Delhi, Jaipur, elsewhere in the country, they want to get an order passed against celebration of a Chunri Mahotsav or celebration. Chunri Mahotsav is basically a way to celebrate the sati, and this is when sati turns very deeply modern, and you could say there's a certain market for sati, because in this mahotsav there are pictures of Roop Kanwar and Mal Singh which are being sold on chunneries. So there is like an economic value in celebrating sati. There's a whole market around her images, her chunneries, bangles are being sold, all sorts of symbols of matrimony are being sold, because technically she died before becoming a widow. She died with her husband. So there was a certain economy around sati, which provoked the state to respond to the glorification aspect of it. And this is why it's distinct from other cases of sati, because glorification is really what the problem was, because this kind of a chunari mahotsav was in one sense glorifying it. And why was it important to criminalize glorification? Because in cases before Roop Kanwar's case, there was a case, for instance, case of Sugan Kanwar. I'll briefly tell you about it because it's interesting, but I won't go too deep into it. But Sugan Kanwar's case is important because in this case, there was no prevention of this Chundri Mahotsav, right? So Chundri Mahotsav happened very soon. There were lakhs of people visiting her shrine. There were lakhs of people claiming that miracles are taking place at the shrine, at the place where this woman kind of committed sati. So how is supernatural relevant to it? Because the woman, I mean, basically the narrative becomes not just about the death of the man, but the sacrifice of the woman. Because the sacrifice is so grand and it's such a spectacle, she becomes almost a goddess. And how is her godly status kind of made sacred? By building a temple. So once you build a temple around it, disseminative ideologies can be formed. Disseminative ideologies will create this idea of superstition and of miracles. And then people started claiming that oh, when we go to the shrine, my eyesight was cured, or I was suffering from cancer and that went away. Then in Sugan Kavar's case, which was in 1960s, the local Raja in Rajasthan wanted to go. So again, you see this problem with between the state and the local narrative, because the police was at this point meant to be spreading literature to prevent sati, but the police also had to make arrangements for the Raja to be able to visit the site of the sati, right? So when there is such local faith and belief in the fact that this was a grand sacrifice, and you can't manage to prevent the glorification, even the state mechanisms, even the courts and your the police apparatus and the lawmaking doesn't know what to do with it. So in Madan Singh, the reason why that becomes significant is because after Roop Cover, the glorification is criminalized, and once you can't glorify it, this is also, to go back to also your about what makes it supernatural, what makes it eerie, was because when, of course, the court said you can't glorify it, so there was no temple dedicated to Roop Kanwar. But Namita Goswami and Paul Cotright have a really interesting essay on what happens when they visit this site in Deorala. Because the temple construction was prevented, the area kind of acquired this eerie kind of a feel, because it was about a death that never got commemorated, right? So because the death was not commemorated, even till date, there's like a makeshift shrine for Roop Kanwar over there. But when you can't commemorate a death, the disseminative ideologies cannot form. And that was the only way to prevent its glorification. Now, this did two things. One thing was that the godly status that the woman was attributed when she became Sati, or when she became a goddess, her powers to bless and curse had to be ruptured by the state in order to make her arrest possible. So after 1987, the woman herself is liable to arrest, right? That is what the new law stated. And once you have that kind of a law and stay in place, you have to make sure that this woman was actually not should not be painted as a goddess in local settings. So in that sense, the Roop Kanwar case became really significant because it made glorification, it criminalized glorification, but it also again made conviction difficult, because if everything is glorification, how do you report a crime on sati? By virtue of becoming an onlooker, you're becoming complicit, because let's say if I take a video recording of a sati and then I tell the police that, look, I saw this. Disseminating that video could also be glorification, right? So how do you then convict? So it didn't address the problems legally, but it did really tackle the question of glorification. Of course, it was not quite tackled, because then you have movies like Padmavat and so on and so forth, which again bring up this question. But this was really about taking away the godly status of the woman in order to make sort of criminal law apply. Because before that, it was becoming such a big spectacle, and sati had such a grand economy to it, that conviction was becoming extremely difficult.
Considering that your abstract mentions gender and vulnerable groups, were there any specific gender dynamics or vulnerabilities evident in the Madan Singh case related to the possession claims or the individuals involved? And how did the court address or overlook them?
So the big case on vulnerabilities, which made me think about vulnerabilities differently, is actually not Madan Singh, but Tej Singh, which happens in 67 or 69 or something. So this case is when your vulnerabilities start to strip. So let's say the vulnerabilities in Sati have always shifted slightly. So let's say in the case of British India, broadly, there was this understanding that in Calcutta, the satis that are taking place, the Bengal sati is because women are being compelled, and the Rajasthan satis is when women are committing it voluntarily. So it is the British who make this distinction between voluntary and involuntary sati, right? So some satis are more vulnerable than others in the British understanding of things, because they're saying some women are being compelled to do it, but if women are happily doing it, then they're not as vulnerable, right? So the first idea of how do you create vulnerability is in on the question of sati is that the tone is being set by how British are choosing to look at it. Of course, they don't factor in that, even if women are doing it voluntarily, what kind of pressures and incidents are kind of leading them to do it. So of course, it's not nuanced at all, but this is the voluntary involuntary sati trope is what the British are giving us. Now, post independence, it's supposed to be something that is bad generally, and you're on the one hand codifying Hindu law, trying to introduce divorce, give women property rights, so on and so forth. So sati doesn't sit well in it, because the obvious connection of sati with property. Of course, if the widow doesn't succeed the man, the motivation behind sati was that the widow shouldn't succeed the man, and therefore she doesn't inherit property. And once you give women property rights, the state suddenly can't be sympathetic to sati. They really have to deal with it as though it's a bad practice. Now, this is the difference between sati and, let's say, other kinds of conversation around, let's say, women being granted the right to divorce. Sati is so obviously criminal law that nobody supports it at any point, right? In post-independence conversations. So how they locate vulnerability is, here you can say that caste is also a factor. One can say that upper caste women initially were more subject to it, because divorce or separating or sati in general was less common with individuals who were non-Rajput, and divorce was more common in individuals who were non-Brahmin. So in one sense, you can say the vulnerability was also due to caste. You can also say that there was some copying of these rituals, because in one sense sati elevated a woman to a certain status. So if a woman of a different caste also committed sati, that elevated her. So you can say that these vulnerabilities are also caste coded. But what's most interesting for me is how the vulnerabilities change post-independence from being this vulnerable woman in need of saving to the helpless police officers who are unable to prevent a sati. Because see, the problem was that the post-colonial state was not convicting people for committing the crime of sati, right? Which is why sati is relevant to somebody like me who's working on lack of conviction due to godly influences, right? So in a lot of sati cases that I read from the beginning of 60s up until 1987, it tapers towards 70s, but in 60s and 70s were about how the police did everything in their capacity, but they were outnumbered by the crowd. The police did everything in their capacity, but the woman was dragged by her relatives. So in one sense, the vulnerability shifts from the insane woman who was kind of drugged or provoked by her family to commit this, to the incapacity of the state. The state just couldn't help it, right? And the state deploys this incapacity argument in various ways. So in terms of bureaucracy, Akhil Gupta and others have made a similar argument. But it was very interesting for me to see that, oh, this helpless police officers and Tej Singh, they're relying on the testimony of this police officer who says that I couldn't actually go there because there were just too many people surrounding the pyre. I was standing on top of a hill and I was viewing it. But even though I was standing on top of the hill, I know exactly who the 12 people were who were responsible for the sati. And in one sense, the court then says, okay, we're going to rely on your testimony because you have no reason to lie. So the case was very complicated because in one sense, the sessions court actually said this is unreliable testimony. But then the higher court said that, no, we will rely on your testimony. But this vulnerability and how it shifts from this woman who is vulnerable because she's being pushed. Now, in order for this vulnerability to shift to the police, the woman has to become insane. So in a lot of the 2000s cases, which is the Kuttubai case that takes place in 2005 in Madhya Pradesh. So here they're trying to really remove her from the godly status and say that, look, this was this insane woman and she wanted to do it anyway. She didn't even live with her husband. She still went and committed sati because they want to they're not able to convict people. They're not able to convict this woman's sons even. They were initially arrested, but then they were let off because of lack of evidence. And because there is such sustained lack of evidence, it becomes a conversation about how police did everything they could. And in the Madhya Pradesh case, the police, which is responsible for disseminating sort of materials for preventing of sati, is also going to the local shrine and kind of touching the ground to their heads, kind of a thing. So there is faith that even the local police is showing in this spectacle, right? So in one sense, it's very hard to address something of this sort because again, it's believing citizens who are implementing rational law. And yeah, that's where the vulnerabilities question is interesting to me in matters of sati.
We'll now move to our next case, which is Kusum Mondal versus Swatin Mondal. Professor, could you briefly outline the facts of this case, particularly focusing on the brutal circumstances which were initially attributed to a ghost?
Yeah, so Madhuri Mandal, it was claimed, was killed by a ghost, and it was a very brutal murder in the sense that her eyes were gouged out of their sockets. There were lacerations all over her body, particularly her neck. Her mutilated body was also found under a banana tree, which was in a garden adjoining her matrimonial home. But the investigation revealed that Madhuri had also been subject to violent abuse by her in-laws over a family property dispute. So the problem was that there was a piece of land that her husband was meant to inherit, and she wanted only her husband to inherit it, but her in-laws wanted that piece of land to be shared between all the siblings and other brothers of her husband, and this had led to a significant amount of turmoil within the family. This was a case where a lot of the prime accused had also fled, but basically it was the argument was that there was such grievous harm to the body. There was such cruelty with which the body had been sort of murdered. The person had been murdered, that they alleged that this could only have been a work of a ghost. No human could have inflicted such harm on another person's body. And as a consequence of this, what turns this case is that it was decided on the basis of insufficient evidence, because the ghost story was relevant to the extent that, of course, the local narrative, when there was no conviction because of lack of evidence, of course, legally, it couldn't be proven beyond reasonable doubt that the husband's family were involved, even though they had fled and so on and so forth. It fueled the local narrative that a ghost could have committed this crime because there was no conviction. So it kind of works both ways. So there's no conviction because there is such brutality and a ghost would have done it. And because there is no conviction, only a ghost could have done it because the police never found anyone. So that was the Madhuri Mandal case broadly.
Since the case itself was determined on lack of evidence, particularly with the witnesses turning hostile, what role could the attribution to ghosts have played in the proceedings of the case?
So this is interesting because the way in which I've used Madhuri Mandal is actually in connection to a lot of other cases where there are similar situations, not exactly similar. In one case, let's say the woman is accused of being a ghost. In another case, she may be killed by a ghost. But nevertheless, the gamut of cases, and I'll discuss the related cases in a minute. All of this to basically say that these cases forward the idea that ambiguity that supernatural generates in a lot of these cases because of ghosts or because of accusations of witches, witchcraft, and so on and so forth, it frequently tends to work against women. Now, Madhuri Mandal's case I've just described. So I'll move on to the next one, which I've discussed in a similar context, which is the case of Mala, who was married to Hemant Kumar. Now, this is also, both these cases are from 2000s. So in Mala's case, she was found in a matrimonial home, having committed suicide by hanging herself from the ceiling of the house. Days after her death, her father lodged a complaint saying that her in-laws and her husband had provoked her suicide because of dowry harassment. Now, her body had to be exhumed 4 days later because of this investigation, and her in laws alleged that she was actually possessed by a ghost, and that's what was making her ill. Now, it was making her ill, it was making her dysfunctional, and apparently, her husband's side of the family had taken her to multiple temple visits over the years in order to sort of exorcise her from the ghost. Now, the way in which this case was ultimately decided was when the Karnataka High Court says that clearly this woman was suffering from a mental health issue and dowry harassment cannot be proven beyond reasonable doubt. Mala had earlier informed her family that she received unsolicited phone calls, and all of this simply shows that she was under severe depression, had a strong beliefs in courts that she was haunted by a spirit or a ghost or somebody that makes telephone calls to her frequently. The Karnataka High Court acquitted all accused. Now, this case is only relevant here because what I'm trying to show is that how frequently, whether you were killed by a ghost or whether you yourself were possessed by one, leading to your death, how frequently charges of dowry harassment are dropped. And this is just, a minuscule number of cases. There I have so many that suggest very similar findings. And I'm not trying to say that all cases of dowry harassments are closed the minute you introduce an element of supernatural. That doesn't happen. But the threshold for punishing somebody for a case of dowry harassment is very, very high. So you really have to prove it to say that even an element of the smallest element of supernatural, smallest element of ambiguity can have the case go completely against you. One more example I will take in this, and then I'll stop at that. So another example, again, this is a case from 1962. It's the Dahiyabai Chagganlal Thakkar case, where a woman had been murdered by her husband. So the lower court had convicted him of murdering his wife, but upon appeal to the High Court, the lawyers introduced the plea of insanity. They said that the man in question had appeared confused. He said very strange things as though he was haunted. And while holding the murder weapon, which was a bloody knife that he had used to stab his wife 44 times, he claimed that he did not know what he was doing, and he kept, saying random stuff and out of anger. And that is why this was a plea of insanity that was admitted. Now, in this case, the court convicts him. But again, the court manages to convict him because this man had written in a letter to this woman's father, to his father-in-law, that he does not like his daughter and he's going to return her daughter. And there was like a series of written pieces of evidence that suggested that this man was trying to get rid of this woman. And therefore, this case became a very easy conviction, and the plea of insanity was thrown out because they said that, no, you've said this in your sane mind, you've written it down, you've said it to people, you've said it to friends, you've said it to her father, so on and so forth. So all of this to basically suggest that the threshold is too high for women to really prove that there was some harassment in order to have their in-laws or husbands arrested. And these are just three out of a whole bunch of cases that indicate kind of a similar argument. All of this to again indicate that the broader argument here is that transgressions of women are not accommodated, whereas emotions of men, or if men alleging superstition or whatever, are quite easily accepted. They're tropes that are easily accepted as defenses in a bunch of cases, particularly in matrimonial disputes. Another example, if I may add just very quickly, like what happens when the law actually does favor the woman. So in this case, by this point, this is a case from 2000. So of course, by this point in Orissa, there is a law against witch hunting. This is the case of Durga Mato. So Jharkhand, sorry, not Orissa, Jharkhand. So Durga Mato case was again when this newly married woman was being harassed by a strong man in the village, an upper caste strong man in the village who was kind of compelling her to sort of enter into an intimate relationship with him. And when she declined it, she was accused of becoming a witch. And when she was accused of being a witch, she was tortured, beaten, and thrown into a temple complex because she was technically a witch. Now, in this case, the anti-witch hunting laws did come into action. So the accused people were arrested, and this woman was kind of, saved from that family. Having said that, this did not significantly improve the conditions for Durga Mato at all, because she still was isolated from the village. She still couldn't draw water from the well, and she still had a lot of people who were treating her as a pariah and were not touching her or going near her. So even when the law exists, and even when the law is very actively in favor of women, very often they will remain on the receiving end of things because, in one sense, cultural patriarchy is allied with legal patriarchy. It finds an ally in kind of state patriarchy that we witness in any other conversation. Like we started this conversation with how in divorce, dowry, domestic violence cases, also women have to prove that they were good women, right? So the incidents or the behaviors that led to women being recognized as a ghost become really significant, and therefore women always have to be great wives, loving mothers in order for them to gain sympathy of the courts.
We will now move to the final question for our podcast today. What are some of the key takeaways you hope policymakers or legal professionals would glean from understanding how courts deal with evidence of the supernatural? Looking forward, what changes, if any, do you think are needed in the legal system or in public discourse to better navigate the complex intersection of law, belief, and lived experiences in India?
Right. So this is an interesting question for me in particular because as a historian, I find myself very unburdened to find solutions because I'm all about the contextualizing and the understanding, but not necessarily about how it could be addressed. Because what I see this as is actually how courts. I mean, this could potentially help in the kind of laws that they're contemplating now because they have anti-witch hunting laws in a bunch of states in India now, Odisha, Jharkhand, Madhya Pradesh. But for me, the real the real merit is in acknowledging the fact that courts are operating in deeply cultural contexts. And in one sense, the instances of possession are more sort of, in instances of possession, the more sort of resilient patriarchal or misogynistic tropes of family, social behaviors tend to get the sympathy of the law. So addressing that, or addressing not just looking at the judgment, but looking at the thinking of the judge in kind of reaching certain conclusions, because again, they're all deploying the law. They're not working, they're all deploying legal, rational law and still not managing to benefit women, right? So it's not so much about a legislative or a legal solution to the problem. It is about acknowledging that even in a solution that is perfectly legal, there is a certain misogyny that the decision might carry. In cases of crimes involving magic, where culpability is even harder to establish, this kind of affects the way in which conviction will take place, the way in which sentencing will take place, and the legislation itself, right? So in both magic or madness, culturally and legally, not only do magic and madness both rely on social stereotypes, they also generate them, they also create them and perpetuate them, right? So we actually have to look at the misogyny in magic, or the misogyny in our understandings of mental illness, or how we accuse women of mental illness. So the broader conversation could also be thinking about grounds for mental insanity as a grounds for divorce, and so on and so forth, and how many women are actually accused of it as in negotiating divorces, right? Very often we also have to look at the fact that one of the reasons why these cases are occurring is because individuals are trying to punish transgressions of women. So very often women who are accused of possession, and the evidence of this is from anthropology, women who are accused of possession very often will be women who have entered in an intercaste relationship, or who've married against the will of their parents. So Clarinda Still has an excellent case study on this, where she shows that this woman, Leela, she is supposed to be this educated woman of, a young woman who holds a lot of promise. Her parents thought she'd make a great match, but she ends up falling in love with this random guy who they don't approve of. And therefore, her family accuses and actually organizes a series of possessions for her in order to displace agency, in order to say that this wasn't the work of Leela, this was the work of the possessing agent. So, one of the ways in which possession takes place is it punishes women's transgressions so that the transgressive behavior can be attributed to somebody else. So what we would have to do in law is to actually get into the question of agency, right? Without getting into the question of agency. If you're only going to say that, oh, mens rea, that's not going to, easy to establish, then we'll have a lot of people going without convictions, right? The other thing is, the other way in which we could, I'm aware that we don't have a lot of time left now, so the other way in which the law could benefit is thinking a little bit more theoretically about where the law locates power and where culture or local locate the power. I say this because it's important in the sense that in law, we could have a person who is accused of witchcraft, who is completely disempowered because they're being treated as mentally ill or sick. Whereas in a cultural context, they can be hyper empowered because they're treated as people or women who are in a position to bless or curse, and therefore they can be killed for it. But in the law, because they're treated as weak and people who are given to superstition, they could be protected for it. So who the law protects versus who the culture protects, and where law and culture are locating power, there needs to be a conversation between them. Finally, the thing to remember is that the fear of the unexplained plays out on the body of the woman in a very specific way. And in adjudicating it, we witness cultural, religious, and state patriarchy operate in a parallel and an allied way. And that would be my takeaway in imagining future policy initiatives.
This now brings us to the end of today's podcast. On behalf of Law School Policy Review, I would like to thank you, Professor Saxena, for joining us today and having this enlightening conversation with us.
Thank you so much. I really enjoyed the questions. Thank you very much.